This Honorable Court of Tennessee is now in session. You may be seated.
Thank you, Madam Clerk. Good afternoon, everyone. This is the afternoon session of our February docket. My name is Robert Wiedemeyer. I serve on the middle section in Nashville. To my right, our presiding judge for the court, Camille R. McMullen from Memphis. And to my left, Judge Timothy L. Easter from Williamson County, also on the middle section. Each side has 20 minutes to argue. We have read the briefs. If the appellant wishes to reserve rebuttal argument time, please announce that prior to arguing, and the clerk will set the timer accordingly. When the red light goes off, it means you've reached your time. You're getting into your rebuttal time, and I'll try to also keep up with that. I think those are all the preliminary announcements I need to make. Any preliminary matters on the docket?
No, sir, Your Honor.
All right, call the first case on the afternoon docket, please.
Earl David Crawford versus State of Tennessee.
Mr. Crawford here on behalf of the appellant.
Yes, sir.
Crawford.
You might need to take the podium, sir.
Pardon? Thank you.
Take the podium.
Thank you. This is my first time here. I guess I'm going to reserve 3 minutes for rebuttal if needed.
Certainly.
Just kind of want to go over a few things. In 1986, the Bradley County jury found Mr. Crawford guilty of armed robbery, aggravated kidnapping, aggravated rape. At the time of conviction, those were Class X felonies, and the trial court sentenced Mr. Crawford to sentences of 35 years, life, and life. But ultimately, the legislature got rid of the Class X designation. Mr. Crawford's position is that under Tennessee law, as it is now, he would be considered a Range 2 offender without the Class X designation. We filed on his behalf on November of 2022 a motion regarding that limited issue. Unfortunately, the trial court dismissed his claim without granting us a hearing, and the trial court stated that he didn't have a colorable claim. It was our position that that the trial court was in error when they denied Mr. Crawford the opportunity to even have a hearing on the motion. This court's aware, colorable claim.
Are you appointed on this case?
No, Your Honor. I just felt that there was an issue and I wanted to help him on it. But Class X felonies do not exist anymore. Mr. Crawford is serving a life sentence in this present case. Life sentences are no longer possible for this type of crime. They're now A felonies. We're not necessarily looking to have Mr. Crawford resentenced. We just would like his judgment amended to reflect the current classification of a felony.
So you're retained?
Yes.
He has paid you to come before this court and submit a brief and argue?
Well, no, Your Honor. Technically, he just hired me to help him in trial court, and I'm here for free today.
Okay. My understanding of the rule is if you are hired at the trial court level, you're hired until you're permitted to withdraw by this court. So you are not here for free.
Okay.
I just wanted to understand what your financial agreement with the defendant was.
Well, it's our position that Mr. Crawford prevented from him having a hearing. Rule 36-1 is to be construed liberally. We think Mr. Crawford's claim is colorable.
What is it? What is the colorable claim?
The colorable claim is that, but when we did some research in his cases, or his case, that Class X felons that are still currently serving sentences, we found people that were serving a term of years. We weren't able to find anybody that was a Class X offender serving a life sentence. And we felt that that differentiated him from other people. And I felt like I didn't see anywhere in the case law where that issue had been argued before. And
What case law?
I just did research on cases where people had been sentenced as Class X offenders.
Is that included in your brief?
No, Your Honor. My
Did
limited
you-
issue before this court,
I'm sorry?
my limited issue before this court is I thought the appropriate remedy at the time was to ask, it was brought up in, I believe, in my trial court brief, but for my brief here, I was just asking for him to have the opportunity to be heard on the matter in the trial court. And he wasn't able to get a hearing in the trial court, and therefore I've come to this court to ask them to give him a hearing in the trial court.
Well, summary dismissal is permitted by statute, correct?
Under certain circumstances, yes.
And what circumstances are that? Did you include that in your brief?
No, Your Honor, I did not.
So you didn't outline what circumstances you think were appropriate in this case?
I did not outline that. There were some things that the Attorney General did outline in her brief as appropriate.
And why didn't you include it in yours?
At the time that I filed this particular brief, I was not aware of those issues.
Okay, we gave you another opportunity to include those issues in your brief.
Right. I just didn't have time to get that part corrected.
You didn't really change your brief in any way, did you?
What I changed was I thought there was just technical issues in it that y'all wanted me to fix some of the parameters in there, and
We
that's
were
what I
very
did.
specific in our order.
Well, Your Honor, I'm sorry if you felt like my amended brief did not comply with your order.
So what do you think that we should do? Because the state put you on notice of the deficiencies in your brief. You did not file a reply brief after the state put you on notice of not only the formatting deficiencies of your brief, but the substantive deficiencies in your brief. Both of those things were problematic, and you were put on notice. Then we put you on notice of those deficiencies, and you still didn't provide us or comply with the rules of this court.
I can see where that's a problem, Your Honor. I would just request that y'all consider our request and then, I guess, rule appropriately.
What is your practice? What practice area do you have?
I do criminal defense,
How long have you done criminal defense?
10 years. This is my first foray into the appellate courts.
Have you had a discussion with your client about our last order?
No, Your Honor.
Have you had a discussion with your client about the state, I guess, the state of your brief and the state's brief?
I've had various conversations with my client about how I'd really rather not get into conversations.
I don't need specifics. I just want to know if you've had, conversations.
I've had conversations with my client about the difficulty of his case.
Okay. And I guess the court's, or this court's order requiring you to amend or supplement the brief that you submitted, you had conversations with your client about that?
I do not want to get into specific conversations with my client.
I didn't ask you to. I asked, had you?
Did I speak to him about the particular order y'all sent?
Yes.
No.
Does your client know that this court has said the brief that you submitted was woefully deficient?
No, Your Honor.
When you received our order to supplement or rebrief, basically, your position, did you read Rule 27 of the appellate procedure?
Yes, Your Honor. And
So why did you not comply with that?
I thought I had, Your Honor.
What did you add to that second brief?
I thought there was issues the way things were cited in the brief, how I didn't necessarily have the proper table of authorities and tell you which page it was on, and that there was a lack of footnotes, which I added. There was certain personal issues I was dealing with. that made it difficult for me to create a brand-new whole brief prior to the deadline that was set by this court.
This case has been continued multiple times, counsel, multiple times. And we also gave you at least 2 weeks prior to this argument to...
I didn't think I was allowed to file anything else after that deadline that was set in y'all's order.
Well, that deadline was only, I don't know, last week? So you've just put us in a very difficult position because your brief doesn't really comply with the rules, nor have you put the issue that you raise in any way such that we could actually rule on it, because we really don't know what you're arguing. You haven't really set that out in your brief. That's at a minimum what is required. We can't read your mind, counsel. And so that's why I asked, how long have you been practicing?
Well, I'm sorry y'all feel that way.
Mr., is it Guerin? Is that how you pronounce it?
Yes, Your Honor.
Yeah. Let me give you just a little bit of practical advice that's been given to me several times and related to this court. We are basically an error-correcting court. A lot of lawyers have come up here who mostly do trial work and kind of present their case to us like we're just like we were the trial court, only we might do something different than the trial court did. But we have to, if what we do is correct, if there are errors made at the trial court, and I don't mean to talk down to you, I just want to make it a little more clear that might help you in the future. If there are errors, then our job is, if they're harmful errors, our job is to correct those errors. So when I read your brief, what I read was that you believe that you did state a colorable claim in the trial court, but the trial court did not agree with you and dismissed your claim. But the problem, maybe this is too simplistic, but your brief, neither the initial brief or the second one, tells us why you think you have a colorable claim. It's just more basically, I have a colorable claim. And so we need to know a good bit more than that, is what it amounts to. And that's why, the issue with your brief is an issue at all. Now, the other advice I would give you, you said, how long did you say you've been practicing?
10, Your Honor.
Okay. And it's mostly in trial courts, I assume, because this is your first trip to the appellate court. So when I was practicing law about 10 years, there was no public defender, and we took appointed criminal cases because the judge told us to, and so we did. And then we, as Judge McMullen pointed out, we were on that case until it concluded at this level. So we had to go into the Court of Criminal Appeals from time to time. But if you have to go in front of this court even one time, it's really a good idea to get familiar with all the rules and everything that's required up here. If you have the luxury with the public defender taking most of the criminal cases these days, you might not have to appear at the appellate level in the criminal system. But if you do, it's really important to get your brief, filed the way it needs to be filed, so that we can, you obviously feel like there was an error here, and if there was, and we corrected it, it would be of great benefit to your client. But your pleadings, you can't just make up for it at oral argument. You can, you might be able to mitigate it, but you need to put it in your brief. Why there was an error and what the correction should be. So I hope what I've said has been helpful. I don't know, but
It has. Thank
it's
you.
what I've got to say about it. So
Can you give us any reason why this appeal should not be dismissed?
I just think maybe in the interest of justice, I think Mr. Crawford's
What are the
particular...
interests of justice?
Well, Mr. Crawford's serving a life sentence, and it's no longer possible under the current statutory scheme to get a life sentence for this type of offense. And we would just, I don't know, this is kind of a last resort thing for Mr. Crawford, basically, to try and have the opportunity to have his sentence changed to where it's, well, I don't want to say change the sentence, just to remove the Class X classification. His judgments, which are on the record, already show that it has a release eligibility date of 35%, but the sentence is life, which is not applicable under the current sentencing scheme. So he was arraigned to offender at the time of sentence, but it doesn't make sense to give somebody a release eligibility date of 35% on a life sentence. We would just like that the Class X be removed and converted to the current Class A as it should be.
And none of that is in the brief.
Well, I agree with you, Your Honor, but that's why I felt like it was appropriate to argue that before the trial court, and the trial court denied me the opportunity to make those arguments. And that's why I came to this court to say, please order the trial court to allow me to make the argument. I felt like those particular issues maybe wrongly weren't ripe. That particular issue wasn't ripe for appeal. I thought the denial of the hearing was more an appropriate thing to appeal, I just felt like, I don't know, if I denied the opportunity if I appealed the denial of a hearing, then if I was able to get an actual hearing in front of the trial judge, my client might have a better outcome.
Okay. Mr. Guerin, I would join Judge Wiedemeyer in giving you advice in terms of how you approach the appellate courts. If you decide to come back or represent another individual before this court, I encourage you to familiarize yourself with the rules in terms of how to format your brief and what is required for a brief and for an issue not to be waived, and for, based on a combination of those two things, why an appeal could withstand waiver and dismissal. I strongly encourage you to review the order that this court dropped in this case and all the rules that we cited in that order before you come back, before you decide to represent another individual before the appellate courts.
Okay, thank you.
All right, General, good afternoon.
Good afternoon, Your Honors. Abigail Renard for the state. This court should affirm the summary dismissal of the Rule 36.1 motion. For reasons already discussed, the petitioner's claim is waived. But even if it were not, he failed to state a colorable claim for relief and was not entitled to a hearing. Here, to the extent that I understand the petitioner's arguments, he's claiming that the criminal savings statute should have applied to get rid of the Class X designation. But the petitioner was convicted and sentenced in 1986, and those convictions were affirmed on direct appeal in 87. The Class X felony designation was not repealed until 1989, well after those convictions became final. This court and the Tennessee Supreme Court have repeatedly held that the criminal savings statute would not apply in those situations. So if this court has no questions, we ask that you affirm the dismissal. Thank you.
All right, to go back to what I was saying to counsel, you're saying that that when the trial court denied the hearing that he's requesting, it was not error?
Correct.
Okay.
Yes.
And the reason it was not error was because there, in fact, was not a colorable claim stated to the trial court that he or she should act on and have a hearing about.
Yes, Your Honor.
Is that correct?
That is correct.
Okay, so without regard to briefing, the essence of this whole case boils down to the state's position. His position is he should have gotten a hearing. It was error not to, and your
Yes.
position is there was no error. Therefore, this court has nothing to do. I mean, there's no relief to be granted.
Correct, Your Honor.
Okay. Thank you, General.
Thank you.
All right, any rebuttal or?
No, Your Honor, you've heard my argument.
All right.
I don't have any to rebut. Thank you.
All right. Thank you, sir. Call the next case, please.